Sorry, ladies and gentlemen, we took a little longer than we thought, but we are here now. We hope we will be able to finish, hopefully, in an hour or an hour and a half, and we'll be done. We have how many rulings we have? How many were there? We have all the rulings ready except two. So we will start reading them. I would give this chance to just Renaola to read the ones he has.
Thank you, CJ. Because of time, I will summarize the decision, which is by the entire bench. The first ruling is that in the application by the third respondent, to strike out internal correspondences between members of the second respondent. We have said as follows in that application: in view of the issues raised by the internal memo dated 9th October 2017, the internal memo dated 14 October 2017, internal memo dated 16 October 2017, and the internal memo dated 16th October 2017, and there shall be no orders as to costs. The reasons for this decision shall be given on notice. And that is signed by the 6 judges of this bench. The second ruling is with regard to the application by the third respondent to strike out certain pleadings filed by the petitioners, and these were Volume 1 in the affidavit of Njonjo Mwe, Volume 2, that is annexure number, Volume 1 of his affidavit, Volume 2, annexure number marked NM21, Volume 9, annexure BA13, in the affidavit of Bilia Tudo, Volume 10A, annexure marked NM21, in the affidavit of Njonjo Mwe, Volume 10B, being an annexure marked BA14 to the affidavit of Njonjo Mwe, and Volume 12B, annexure marked BA40 to the affidavit of Bilia Tudo. Having looked at the submissions by the parties, and we have given reasons why, we have determined as follows. Prayers A to F, with regard to the striking off of various documents from the affidavits sworn by Njonjo Mwe and Bilia Tudo on 5th November 2017, are hereby disallowed. B, the prayers seeking the striking off of the reference to an affidavit by James Gondi at paragraph 76 of the affidavit on Njonjo Mwe, sworn on 5th November 2017, is hereby allowed. C, as a consequence to order A above, the prayer seeking the striking off paragraph 74, 75, and 30, 31, and 61 of the affidavits of Njonjo Mwe and Bilia Tudo are hereby disallowed. There shall be no order as to costs. Signed by the 6 judges of this bench. Thank you, CJ.
The next ruling will be read by Justice Joki.
There were 2 applications for interested party by Edwards Kings Onyancha Maina, one in election petition number 2 and the other in election petition number 4. We have considered the application, and by unanimous decision of the court, we find that the applicant does not qualify to be joined as an interested party, and we disallow his application in both petitions. In summary, there is an application for interested party by the Attorney General. We have looked at the application, and upon considering the following arguments by the applicant on the merits of the application, that 1, his application meets the criteria for joinder, that the instant petition raises grave allegations touching directly on the roles played by state and public officers and officers regarding their manner of participation in the fresh presidential election, that some of the issues raised in the petition touching on the conduct of state and public officers were live in cases in which he has represented the national government. We have, having considered those grounds, and by unanimous decision, we find that the application meets the criteria, laid out in the cases of Mumu Matemu and Muruatetu, and therefore the applicant qualifies to be admitted to these proceedings as an interested party. It's signed by all 6 judges.
Thank you, Justice Njoki. Justice Ojwang.
This is petition number 4 of 2017. Upon perusing the application and reading the written submissions in support of the application, and upon considering the 4th respondent's reply to the same, having considered the oral submissions and arguments by a unanimous decision of the court, we find that NASA cannot be sustained as a respondent in this matter. In view of the limited time, the court will give detailed reasons for this decision on notice. Any references to NASA in petition number 4 are expunged from the record of the court and make orders accordingly.
Thank you, Justice Ojwang. The Deputy CJN.
Thank you, Chief Justice. I have the application by Ekuru Aukot, and this is our unanimous ruling that he meets the criteria in Momo Matemo and Muruatetu and is therefore joined as an interested party. Chief Justice, I then have the one for the Jubilee Party that seeks to be joined. The Jubilee Party has applied to be joined as an interested party in petition number 3 of 2017. In the course of hearing that application, counsel for the respondents have raised a preliminary objection challenging the jurisdiction of this court to entertain the petition. Today and for the next 2 to 3 days, this court will be engaged in hearing 2 petitions under Article 140, challenging the election of the Honorable Uhuru Muigai Kenyatta and the Honorable William Samoei Ruto as President and Deputy President of the Republic. Petitions under Article 140 are time-bound litigation which must be determined within 14 days as required by Clause 3 of that article. This petition does not challenge the election of the President-elect. It is brought under Article 163, Sub-Article 3 of the Constitution. It is therefore not a time-bound petition under Article 140 of the Constitution that we must hear within 14 days. It cannot therefore be heard alongside petition numbers 2 and 4. It is accordingly taken out of the course list of the matters to be heard between today and the 13th of December. We do not even have time to rule on the said application to join Jubilee Party or on the preliminary objection raised by the respondents. In these circumstances, we defer those rulings to a date to be given on notice. Orders accordingly. Thank you.
Thank you, DCJ. The next ruling we have is one by the Honorable the Attorney General to be joined as amicus in petition number. Which one is this? Petition number 2. I will read the orders. Having considered the application by a unanimous decision of this court, we find that the Honorable Attorney General does not qualify to be admitted as amicus in these proceedings because his application does not meet the threshold set out in the Matemu case. In particular, the Attorney General's amicus brief does not address points of law not already addressed by the parties to this suit, so as to introduce only novel aspects of legal issues in question that aid the development of law. Consequently, we hereby make the following orders under Rule 54 of the Supreme Court rules. Number one, the notice of motion dated 13th November 2017, seeking orders that the court grants leave to the Honorable Attorney General to appear as amicus curiae in these proceedings is hereby denied. We make no order as to costs. The other application, the other matter is this one in petition number 4. In his petition, dated 1st November 2017, Honorable David Kosing, the Member of Parliament for Pokot South, I will hereinafter refer to him as the applicant, seeks 16 declarations. The gravamen of his prayers is that the acts of Raila Amolo Odinga, Stephen Kalonzo Musyoka, Wycliffe Musalia Mudavadi, and Moses Masika Wetangula, together with their political parties, the National Super Alliance, Orange Democratic Movement, Wiper Democratic Movement, Ford Kenya, and Aman National Congress, as well as their supporters, to boycott, sabotage, and frustrate and or obstruct the conduct of the 26th October presidential election amount to treason and an attempt to establish a government in Kenya other than in accordance with the Constitution. Honorable Kosing seeks a further declaration that Honorable Uhuru Muigai Kenyatta was lawfully elected in the fresh presidential election held on the 26th October 2017. On 3rd of November, the Deputy Registrar of this court directed that the petition be served upon all the respondents and that the matter be mentioned before him on 15th of November to determine compliance with those directions before a hearing date is fixed. On 12th of November 2017, the Deputy Registrar took the file to the Honorable the Chief Justice and sought guidance in the matter as Mr. Kibe Mungai, learned counsel for the applicant, was demanding that this petition should be heard before the 17th of November 2017. Upon perusal of the petition, the Honorable the Chief Justice directed that, and I quote, as the Supreme Court is engaged in hearing time-bound petitions under Article 140 of the Constitution, I direct that this petition be heard by the whole court on priority basis after 13th of December 2017, end of quote. Undeterred, the applicant has returned to this court with an application under Section 24 of the Supreme Court Act and Rule 16 of the Supreme Court Rules, seeking that his petition be consolidated and heard together with this petition. We suppose he is referring to petition numbers 2 and 4, filed by Haron Mwau and Njonjo and another, challenging the declaration of Honorable Uhuru Muigai Kenyatta and Honorable William Samoei Ruto, respectively as President and Deputy President-elect. We are this evening going to give directions and commence the hearing of those petitions tomorrow. Honorable Kosing's application cannot be granted for the simple reason that it does not fall within the purview of Article 140 of the Constitution, which requires petitions challenging the election of the president-elect to be filed within 7 days of the declaration of the results of the presidential election and heard and determined within 14 days of filing. Honorable Kusing's petition is not seeking to challenge the declaration of Honorable Uhuru Kenyatta as the president-elect. As we have said, Honorable Kusing's petition is seeking declarations to the effect that the acts of Honorable Raila Odinga, Honorable Kalonzo Musyoka, and their supporters to boycott and attempt to sabotage the conduct of the elections on 26th of October 2017 amounted to treason and an attempt to unconstitutionally establish a government in Kenya. If this court loses focus and succumbs to the pressure and allows all cases by parties aggrieved by the conduct of a presidential election to be heard within the period of 14 days allowed by Article 140, it will be swamped by an avalanche of petitions. It will not be able to determine within that time frame and occasion a constitutional crisis. In the circumstances, we decline to grant this application. We have, as we have stated, Honorable Kusing's petition is not a time-bound litigation. It will therefore be heard with others after this court determines the petitions challenging the election of the president. Those are the orders of the court. The remaining rulings are the ruling seeking the scrutiny, the application by the petitioners in petition number 4, seeking scrutiny. That ruling will be delivered tomorrow. The other ruling is one by Mr. Oganga to be joined in one of the petitions. That one is also not ready, and it will be delivered tomorrow morning. And with that, now we have finalized with the applications, save for the ones which we are going to deliver the rulings tomorrow. And we want to now go to the what? To the pre-trial directions in these matters.
My Lord Chief Justice, in the light of the decision made by this court, then the NASA team would pray to be excused from further proceedings.
Very well. NASA team, and I believe the others whose matters we are not going to hear, you are excused to leave.
You're most obliged, my Lord.
Thank you.
See you in the next life.
Yes, as I was saying, we have two petitions. One by Honorable Aaron Mwau, who is representing him. Mr. Maybe we can now get the quorum given by Senior Counsel, Mr. Who is, or you want each party to. Yes, okay.
My Lord and ladies, my name is B.M. Musyoki. I represent the petitioner together with three other advocates.
Yeah.
Mr. Mark Ngatia, Mr. Aluoka, and Mr. Mark Ouma.
Are they here?
Yes, they are here.
They should at least show. Yes, okay, very well. Then who is for the petitioner in petition number 4?
Yes, my lord. Present this evening is myself, Haron Dubi, with Jen Odia, holding brief for the others who are in the office working on the papers. We were in the morning with Julie Soweto, Don Dea, Waiko Wanyoike, and Eunice Lumalas.
Okay. Very well. For the respondents, let's have the representation. Who is for?
I'm for the first respondent. My name is Kimani Mohoro. I'm with Mr. Sisule, Mr. Morogo, Mr. Wambu.
Yeah, okay. For the second respondent?
That's the chairman. That's for the chairman.
The chairman of IBC.
IFC.
Yeah, may it please, my lords. My name is Waweru Atonya. I appear for the second respondent, together with my learned friend Lucy Kambuni here on my right, Kamau Karori,
Yeah.
Eric Gumbo, and last but not least, Mahati Somane.
Yes.
This one, my lord, is not Mahat. It's not Mohati, it's Mahat.
Yes.
Thank you, my lord.
Thank you, thank you.
My lords, I appear together with Mr. Ahmed Nasil, Senior Counsel, Ken Ogeto, his left, Kimani Kirago, Melissa Ngania, Miss, Hilary Sigei, Tom Masharia, Erija Mwangi, Mr. Katwa Kigen. That's the team. Thank you very much.
Very well. Thank you.
Sorry, Mr. Reguero.
Oh, Mr. Reguero.
A terrible story about that.
Yeah, okay.
Mr. Reguero.
Very well. Yes, we have the interested party, Mr. Ekuro. Sorry, Mr. Just a minute, Mr. Muturi, you.
If so may please you, my lords and my ladies, my name is Jay Muturi.
Yes.
Solicitor General, I appear for the AG, together with Samuel Kaumba, in the back, and Modoni Kanyugu.
Okay, okay, thank you.
May it please the court, my name is Elias Mutuma. For the second interested party, Dr. Kura Court,
yes.
I appear alongside Mr. Ignatius Mohatia and Ms. Safi Nombuya.
Thank you. Any other party we have left? No, that is the representation. Okay, we have two petitions. How do you want us to proceed, Mr. Ngatia?
My lords, I have thought about this. I've consulted my colleagues. The first petition, which is number 2, raises a single issue.
Yes.
It's a single issue petition. And accordingly, I have only drafted 4 issues for determination in that petition.
Yeah.
That, my lords, can be heard on its own. It's a process, I think, we did in 2013. We had one petition which was a single issue petition on its own. Petition number 4 raises quite a number of other issues. Before I finish with petition number 2, not much time would be required for oral submissions. I see that as being a very engaged petition. And then petition number 4, raising more issues, could be heard on its own. But come delivery judgment could be consolidated. But for purposes of arguments, I think arguing them one after the other may be a quicker way, so that we don't leave any issue unanswered.
That petition raises, as you have correctly stated, one issue.
One issue only.
Of nomination.
Yes.
Nomination is also raised in the other petition.
Yes.
So why do you want this one heard singly and then we go to the next one?
Because once we have dealt with nominations in this, we will not spend too much time in petition number 4. In petition number 4, nomination is not such a pivotal issue as it is.
But it will be argued. That issue will be argued also.
Yes.
If you argue the issue of nomination in this petition, you will come again and argue the same issue in petition number 4.
I see, my Lord, yes, then one is talking of having both petitions heard together, which is also fine with us. It is quite fine with us, my Lords.
Yes.
Because we bear in mind that in this one is single issue. Once we have dealt with it, we have dealt completely with it, and then we go to the other issues.
Yes.
And then it will be a question of how arguments will be advanced, and that is a matter I think we can agree upon as council.
Yeah.
Yes.
Okay. Ladies and gentlemen, although he has not put it in so many words, can we have these two petitions consolidated? Anybody with a different view?
Not quite a different view, only to correct my senior personal friend, Mr. Ngatia, that he said he had consulted with his colleagues. Oh, you should have said so. Yes, he had only consulted with his team. We would have no particular or strong views against consolidation, so long as we negotiate the time allocation adequately.
So,
for the second respondent, my Lord,
yes.
We have the clear view that, for one very good reason, that the issue of nomination is common to both the petitions.
Yes.
And like Your Lordship clearly indicated, even if we were to deal separately with the petition number 2, which involves the issue of nomination, we would still have to address the same issue in the other petition. And to me, it makes a lot of sense in saving time to have the two petitions consolidated.
Thank you, Mr. Patonya.
Perhaps then, my Lord, because petition number 4 raises a multiplicity of issues, we could consider having it as the lead file, so that because that one issue on nominations is common, we can have number 4 as the lead file because it contains broader issues as a basis.
My Lords, for the first respondent, I wish to support what Mr. Weru has said.
My Lord, on behalf of the petitioner in number 2, as much as my learned friends are right that there is an issue of nomination, it is our opinion that that is not the only issue in that petition. We filed our issues yesterday after sending emails to my learned seniors, and we failed to get any response. So as we consider the issues, let it not be that it's a common ground that our petition raises the issue of nominations only. There are constitutional issues raised in our petition.
What other issues are raised?
The manner in which the elections were conducted. It's raised there. Mm-hmm. But I do agree that there are common issues, but ours, it does not raise issue of nominations only.
Yeah, but you are for the petitioner in
yes.
petition number 2.
Number 2, yes.
And you are saying you raise more than one issue.
Yes.
Which is the second issue, the third issue?
The second issue, my lord, was whether there is an issue of whether actually the elections should have been held on 26th of October. The elections, yes. And even the number, the number of the way the gazettement was made. Yes.
Yes, address the issue of consolidation. We know how to deal with the...
yes, my lord. I was just making clarification.
Okay,
I have no problem with the consolidation.
Do you have an objection to consolidation?
No.
Yes, okay. So do I take it counsel that by consent the 2 petitions be consolidated?
Yes.
Mr. Ndubi, you are saying because petition number 4...
Because it's embellished. It's big. It can be the lead fire. Yes.
Yeah, okay. We will decide which one is the lead file. Yeah. Now, with the consolidation, Mr. Ndubi, you are overruled. The read file will be, petition number 2. So we will go on like that.
Very well.
Yes, now, with that consolidation, it means that Honorable Mwau is the first petitioner. Mr. Njonjo Mwe is the second petitioner. And Mr.
Khalif Khalifa.
Yes, he is the second petitioner. Third petitioner, sorry. Then, Dr. Ikuro Aukot is the first interested party. Sorry.
Perhaps, my lord, before you read the order of the respondents, between the chairman, who is a respondent, and the IBC, of which is the chairman, we have agreed that IBC should come before the chairman. We would like the order that the IBC comes before the chairman.
Okay,
yes.
very well.
Yes.
So IBC is the first respondent.
Yes.
The chairman of IBC is the
second respondent.
Yeah. And the Honorable Uhuru Kenyatta is the third respondent.
Yes.
Then the first interested party is Dr. Ikuro Aputo. The second interested party is the Attorney General. So we will go in that order.
Yes.
Now, I want you to tell me the time you think each part requires.
My lord, before you go to the time, I want to seek some clarification in enjoined of the AG as amicus. As far as I am concerned, he was not joined in petition number 2, but when you are doing the quorum, I believe I heard a representative from the AG saying that he was joined. So
Is he joined as an interested party?
Okay, thank you.
Not as amicus. Yes. You have not given us the time.
My Lord, between ourselves, we thought that around 1 hour and 20 minutes will be enough.
How many?
1 hour, 20 minutes.
1 hour?
20 minutes.
20 minutes?
Yes.
Yeah? That's your proposal? Mr. Andubi?
Yes, my Lord, we will...
The two of you are in one petition?
Yes, Jen and I are in one petition.
Yeah, so?
We will require no less than 3 hours on our part.
3 hours?
Yes.
Okay. Mr. Who is for the IBC?
I am.
Mr. Gatonya?
My team, yes.
Yes.
My Lord, before I give an indication about the time, it's good to give some idea about what it entails the IBC to be able to respond to all the allegations made. It is the punching bag of most of the parties. And for this, my Lord, we require a minimum of 3.5 hours.
IBC alone?
Yes, we have a lot of allegations made against us. Copious affidavits.
Very well. For the
position is similar. We have a lot of allegations against the chairman. And we require also 3.5 hours.
3.5 hours?
Yes, to deal with those matters.
Yeah.
It's also a big punching bag.
Okay. For the first for the third respondent?
Perhaps, my Lord, before we go to the third respondent, if I may request, my colleagues who are in the office preparing our paperwork and watching these proceedings are thinking that 3 hours is actually too low. It's all right.
Yeah.
2, there must be equality of arms between us, and I recognize that the respondents and the two interested parties are likely to be on one side against us. So I will revise our request and ask for a minimum of 5 hours to present our case.
Very well. Mr. Ngatia?
Mr. Ahmed Nasir is the one who is doing mental calculations about the time. I invite you.
My Lord, I don't know what problem my learned friend have been saying that we require 4 hours.
4 hours?
Yes, my Lord.
Yes. And
if it pleases the court, 1 hour is enough for us.
1 hour?
Yes.
We'll be requesting an hour as well.
Yes. Thank you.
My Lord, I don't know whether you allow me. I've consulted with my team, and they are requesting, my Lord, that we revise hours to 2 hours.
To 2 hours?
Yes.
Okay, let's add. Can somebody do the calculation quickly? The first petitioner wants 2 hours. Hmm? No. That one. 5. Eh? You want 2 hours? You are for Mr.
For Honorable Mwang, 2 hours.
2 hours?
Yes.
That's why I said the first petitioner.
Yes. Yes.
Mr. Ndubi, you want 5 hours?
5 hours.
That is 7. IBC, 3.5 hours. Yes, 7 plus 7 is 14. Then, plus 4. 20 hours. Yes. We have not even given allowance for rejoinders. You have added the ones for the interested parties?
Yes, sir.
Yes. And they have come to? 20 hours.
1 day, 1 night.
One day, 1 night. Is that practicable? Gentlemen, ladies and gentlemen? Because one thing we should be clear. You have done written submissions. You're not going to dictate or to read through those written submissions, and we have them. If that is the case, you take back the written submissions and you submit orally so that we have it, because it is being recorded verbatim. We have the affidavits. You are not going to read, Mr. Ndubi, please listen to me. You have affidavits that you have filed. You are not going to read through all the paragraphs of the affidavits, because then it will not make sense for you having filed them, because we will read through them. So if we give you those hours, we will be here, I don't know until when. And yet, we have to determine. We have to determine this matter latest by Monday. So, because you have given your proposals, we will consider, and we are the ones to give the time each of you will take.
Even though...
Sorry? Come forward. Who are you? Give him the microphone.
My lords and my ladies, I have an application dated on 7th 11th 2017. It was lodged on the same day. In fact, it is an ex parte application.
Who are you?
I'm an applicant in this matter.
What's your name?
My name is Ben Caleb Wamaya. An applicant in this matter. I lodged my application on 7th of 11th, 2017.
Okay.
Yes, and it was an ex parte application, and it was not. It was not opposed by any party.
Yes.
Yes.
Yes, Mr. Wamaya, sorry. I'm sorry. Yours will be delivered tomorrow also.
Thank you.
Yeah, it was an oversight on our part. It will be delivered tomorrow.
Most obliged.
Thank you.
Yes, my lord, I was going to say that two things. One, our petition is quite detailed and wide, raising more issues than even those who were raised in petition number 1 of 2017. Two, as you consider the time allocation, of course, we invite you to recall that you limited our written submissions into a very, what we considered quite short, but it's fine, so that may help in determining how you allocate us the time for oral submissions. Thank you.
Ladies and gentlemen, we must manage time. Before I give you the time indication, do you have a statement of agreed issues? Joint statement of agreed issues. You didn't even attempt to do one? Yes. What we do is you will frame your own issues that you want to raise in your what? Your petition or response. We will, or you have already done that, and you have filed. Yes. You have filed. You will each, you will argue your issues within the time you are given. And we are going to be very strict on time. When your time is over, we will switch off the what? The microphone. So it is up to you to manage your arguments within the time that we are going to allow you. We have taken into account the issues each of you, in our view, needs to consider or needs to put before court. For the first petitioner, you have only 1 hour. Mr. Ndubi, for the second and the third petitioners, you have 2 hours. The first respondent, that's IBC, you will have 1.5 hours. For the second respondent, you will have 1.5 hours. The third respondent, Mr. Ngatia, you will have 2 hours. And for the first interested party, you will have 1 hour, 30 minutes. The second interested party, you will also have 30 minutes. And rejoinders, we will adjust the time accordingly. So, ladies and gentlemen, organize your arguments to fit within those timelines that we will give. Yes. Give him the microphone.
Your Lordships, with your kind permission, my name is Kings Maina. You have delivered a ruling determining my application to be enjoined. I have an issue. I'm a voter. I'm not just an applicant. Election of a president is about voter rights. You are at the final court. You have denied me the right to be heard. You have denied me access to justice. Where do you wish I go to? Where do you wish I go to? My application was going to terminate the whole petitions in 15 minutes. You have taken me for granted. You have abused my rights. Whom do I go to? I pay taxes, which runs this court. And this court is championing abusing my rights. Where do I take recourse to? I need my right to be heard. I'm not a joyrider, not a busybody. This court is not for busybodies. I'm here as a party and a voter. My rights have been abused. They were abused on 1st September. I tried to come on board. I was locked out by a deputy registrar, and one of your colleagues sustained that locking me out. I feel abused. I feel denied my citizenship. What do you people want me to do? Do you want me to go home happy I have a court? Or do you want me to go home complaining to who? Thank you.
Very well. One minor. We have heard you. You are one of the 19 million voters in this country. If we allow each of the 19 million voters to come and be heard in these petitions, we will need some 2 years to determine. I don't know, even 2 years will be enough. You have made your application. The court has ruled on your application. The other applications have been made here. Some we have allowed. We have even dismissed the AG's application, which is ought to be joined as an amicus curiae, because in our view, his arguments are the same as the ones which have already been, which are being presented by other parties. So we have made our ruling. Too bad we have not allowed you, but that is the order we have made, and it's a considered ruling. We have made that. Thank you. So tomorrow, ladies and gentlemen, we propose to start at 6:30 in the morning. Sorry? You are saying we can as well stay on until... Okay, ladies and gentlemen, tomorrow we will start at 10. We'll all be seated in court. We start at 10, and please stick to the time given. Synchronize your arguments. As I said, you don't need to read through, towards the submissions which are already written, or the pleadings which are in the file, which we are going to read. So we start tomorrow morning at 10 o'clock. Thank you.
My Lord, on my part, one little thing. Because of the ruling that was read regarding Mr. Ngatia's application affecting our petition, we would like, if we can get a copy of that ruling to enable us refocus. Because I think, I understand that there are some documents that were expunged from our petition, so we need to refocus.
The documents are in the application which you have, so really, why would you need anything else?
No, I'm saying a copy of the ruling only.
The ruling has no reasons. It is merely, it has no reasons.
Yes.
It's only expunging the documents in Mr. Ngatia's application, which you have.
Okay. Okay, thank you.
My Lords, I've been reminded that we will need video equipment. The same can be available, just in case. Maybe the registrar can be ordered to provide the equipment.
If they are not procured with the procurement difficulties they have.